Here's an update from the law offices of Robin Bresky.
Another update from the law offices of Robin Bresky. On February 9, 2017, the Ninth Circuit Court of Appeals in California denied the federal government's motion for an emergency stay pending appeal in the case of State of Washington versus Donald J. Trump. This case illustrates interesting principles of civil and appellate procedure, so the appellate lawyers at the law offices of Robin Bresky have a unique perspective on the unfolding drama of the legal challenge to the executive order on immigration. Among other things, the executive order temporarily suspended the U.S. refugee program and immigration from 7 nations. It also provided case-by-case exceptions to some of those restrictions. Additionally, the executive order suspended entry of Syrian refugees until the president is satisfied that the vetting process has been improved. Several lawsuits were quickly filed seeking to block the president's order. For example, the states of Washington and Minnesota filed suit and argued that the travel ban harms their states economically and harms certain people seeking to return to the U.S. The states argued that the executive order discriminates on the basis of religion and nationality. The states filed an emergency motion for a temporary restraining order to halt enforcement of the president's order while the case proceeds in court. The Department of Justice responded, emphasizing the president's authority over foreign affairs and national security and arguing that the states lack standing and are unlikely to succeed on the merits. The government argued that the executive order complies with a statute that allows the president to suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens and restrictions he may deem to be appropriate. However, the plaintiffs argued that this particular executive order was based on discriminatory intent and was overbroad. After a hearing, the federal district court issued a temporary restraining order blocking certain parts of the president's order. The Department of Justice appealed to the Ninth Circuit and filed an emergency motion asking the appellate court to let the executive order be implemented during the appeal. On February 7th, the Ninth Circuit held oral argument by telephone. 2 days later, on February 9th, the appellate court denied the government's motion for an emergency stay pending appeal. Now the appeal will proceed on the merits, and the court will also allow the government to file a motion for reconsideration of the February 9th order. Regardless of the outcome, it is likely that the Supreme Court will be asked to resolve the matter. The briefs and oral arguments in this case illustrate the type of procedural issues and legal analysis that appellate attorneys are adept at handling. The appellate and litigation support lawyers at the law offices of Robin Bresky enjoy researching the law and writing a clear analysis to apply the law to the facts. The law offices of Robin Bresky, depth of research, strength of knowledge.
For more information, visit BreskyAppellate.com.